This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, I'm going to speak about why it doesn't pay to lie to your insurance company and why any material misrepresentation, whether made intentionally or innocently, will cause a policy to be declared void from its inception and never have existed. Plaintiff Security National Insurance Company moved for summary judgment on its suit for declaratory relief that the insured Salient Landscaping, Inc. misrepresented material facts sufficient to allow the insurer to rescind the policy. In Security National versus Salient Landscaping, an October 26, 2022 decision of the United States District Court for the Eastern District of Michigan, the court resolved the dispute. On March 21, 2018, Salient, by its owner Chris Fox, applied for general liability insurance coverage from AmTrust North America, an affiliate of Security. The underwriting information section of the insurance application describes Salient's operations as basic landscape lawn care service, maintenance and gardening, moving, mulching, planting and/or installation, and identified its work as landscaping and gardening. Salient responded no when asked whether it had performed, supervised, or subcontracted snow removal work in the past 10 years. The application included a letter entitled Loss Warranty, which provided that Fox, among others, 1. warranted and represented that he inquired into Salient, and that when the application was executed, he did not know any undisclosed claim, fact, proceeding, circumstance, act, error, or omission, which had been or might be expected to give rise to a claim, and 2, understood and accepted that the policy may be canceled or rescinded should it be determined that Salient violated its representations and warranties. The application also contained a warning in capital letters that, quote, any person who, with the intent to defraud or knowing that he is facilitating a fraud against an insurer, submits an application or files a claim containing a false or deceptive statement is guilty of insurance fraud. Fox signed the application, acknowledging that he had read and understood all the questions asked in the application and had provided all information required. On March 22, 2018, Security issued the commercial lines policy to Salient for the period from March 22, 2018 to 2019. The policy required Security to cover and or defend certain liabilities to bodily injuries or property damages arising out of the conduct of Salient's business. The policy also provided, under Commercial General Liability Conditions section, quote, by accepting this policy, 1, you agree, 1, that the statement in the declarations are accurate and complete, 2, those statements are based upon representations you made to us, and 3, we have issued this policy in reliance upon your representations. On or about February 7, 2022, Security was notified of Hutchinson's lawsuit against Wellesley and Salient in Michigan State Court arising out of a November 2018 slip and fall on ice incident. This was the first time Security learned of Salient's involvement in snow removal work. The court, in reaching its conclusions, was asked only to address whether the policy should be rescinded because of Salient's misrepresentation in the application, an issue independent of claims made in the injured party Hutchinson's lawsuit. The federal declaratory action would settle only the legal relations between security and the defendants, which will not impair or confuse the state court's analysis because security is not a party to these proceedings, and the state court has dismissed all claims against Salient, thereby halting any further involvement by security in that case. Additionally, there was no evidence that the declaratory remedy is being used merely for the purpose of procedural fencing or to provide an arena for a res judicata, and the court need not assume otherwise. The declaratory action would not increase the friction between federal and state courts and improperly encroach upon state jurisdictions, as there are different parties and there is no overlapping factual or legal issue. Finally, there has been no suggestion of a better or more effective alternative remedy. Where the moving party, in its motion for summary judgment, has carried its burden of showing that the pleadings, depositions, answers to interrogatories, admissions, and affidavits in the record construed favorably to the non-moving party do not raise a genuine issue of material fact for trial, entry of summary judgment is appropriate. A fact is material for purposes of summary judgment when proof of that fact would have the effect of establishing or refuting an essential element of the claim or a defense advanced by either party. Under Michigan law, where an insured makes a material misrepresentation in the application for insurance, the insurer is entitled to rescind the policy and declare it void ab initio, meaning void from its inception. A false representation in an application for insurance, which materially affects the acceptance of the risk, entitles the insurer to cancellation as a matter of law. Rescission is justified without regard to the intentional nature of the misrepresentation as long as it was relied upon by the insurer. This proposition holds even in cases of innocent misrepresentation so long as a party relies on the misstatement and is deceived. There was no dispute that Salient made a misrepresentation in the application when it denied having performed supervised or subcontracted snow removal work in the previous 10 years. In fact, 5 months earlier, Fox, the signatory in the application, signed the Snow Contract 2017-2022, which allowed Salient to perform snow removal and de-icing services for the community. Security has offered unrebutted evidence that the policy as written would not have been issued but for the misrepresentation of no snow removal operation. Also unrefuted was the fact that security does not provide liability coverage to its insureds for snow removal operations, and no premium was charged for this liability exposure. This demonstrated the heightened risk that security wanted to avoid from its insured snow removal operation. Accordingly, the United States District Court concluded that there was no genuine issue of material fact, and security had the right to rescind the policy based on the material misrepresentation made by Salient in the application. With the policy rescinded, the parties must be returned to their respective pre-contract position. Security must return all premiums paid by Salient to restore it to the pre-contract status quo. On the other hand, security can recover the reasonable defense cost expended to defend Salient in the underlying lawsuits. In my opinion, since Salient signed a contract to remove snow more than 5 months before signing the application for insurance, It knew that the answer on the application was clearly and intentionally false. Even if the application signer, Mr. Fox, had forgotten about the contract, the innocent misrepresentation is still sufficient to support the rescission because the insurer was deceived, and had it known the truth, it would not have issued the policy. Therefore, the court returned the parties to the position they were in before the inception date of the policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who goes to the URL zalma.com/blog. You can subscribe to the blog and receive notice at least 5 times a week of every new blog post. And you can also subscribe to the videos on rumble.com and youtube.com. And if you watch the videos and find them useful, please click on the like button or the rumble button as you do. And please inform your colleagues and friends about the availability of these blogs, which are now more than 4,500, and of these videos that are more than 550 on rumble.com. You can subscribe to the videos, and I'd appreciate it if you watch the video that you click on the like button or the rumble button as you do so. And I would hope that you would also consider viewing my Locals channel and my Substack publication. Thank you for your attention.